Assalamualaikum warahmatullahi wabarakatuh and salam sejahtera. So today we continue with the discussion on law of agency. So when talking about the law of agency, right? It is always related to the contract law. But in this uh, in the law of agency, there is some extension to the law of contract whereby it actually add on some obligation for another party, obligation also the liability of the, the another party, which is the agent. If talking about the contract, it might be involved between two parties, either offeror and offeree. But in the law of agency, in agency law, there is another party involved, which is called as an agent. So basically, there are three parties in this law of agency. So the learning outcome of this chapter, so firstly, you would student can explain how an agency relationship is created, and explain the authority of an agent, explain the agent duty towards principal, and the agent's rights against the principal, explain the liabilities of principal and agent to the third parties, and lastly, they describe the termination of agency. So all these subtopic that you are going to learn, but most importantly, at least you can grasp the first, second, and the third one. So 1, 2, 3, you can understand in depth, then is better enough, right? Okay. So what is the agency? So under the law, there is the contract actually doesn't define, or any other law doesn't define what is the agency. The but it can be understood as the relationship, which subsists between principal and agent, where the agent has been authorized to act for the principal or represent him in dealing with others, i.e. the third party. So in other words, it is more on relationship between among three parties. One is the principal, number two is agent, and the agent represent the principal as an agent to the deal with the third party. So there are three parties, as I said just now. And these three party actually they are making a contract. They are making contract. The only thing is that the principal has delegated his power, his authority, to the agent, so that the agent can represent him, as if that the principal makes a contract with the third party. So that is the only things that different between the offerer and offeree. So meaning to say, in the case of the offerer might offerer might appoint a person which is called as an agent to deal with the offeree. So in some circumstances, might be that the offeree can also appoint the agent. So we need to say agent to agent lah. So because in the commercial matters is sometimes it's very complicated, right? The world is becomes complicated, whereby it is involved many parties. So so the principal might be busy, so he appoints another person as his agent to deal with the third party, right? So basically the laws that govern the agency is um, allocated in the Contract Act 1950. For example, in section 135, it defines agent is a person employed to do any act for another in dealing with third party, just who is an agent, and who is the principal also is defined under section 135. Principal is the person to whom such act is done or is so represented. Right. So this is the diagram, illustration, how that relationship subsists between principal, between agent and the third party. For instance, if Ali appoint Mutu to buy some goods on his behalf, Ali call the principal, while the Mutu is in his agent, right? And then the seller of the goods is called as third party, third person. Right. So there must be at least three parties. Three parties. Three parties doesn't mean three persons. It might be more than three. In terms of number of persons, it might be more than three. So don't be confused on that, right? But in terms of party, it must be three parties. In terms of persons, it might be more. For instance, principal might be two. Principal might be two persons, whereby these two persons have actually joined, we call it a business, as a partnership. It might be a company. So the principal might be a company, right? And the agent also might be a company as well, right? And the third party might be also a company. So company might have certain members, right? So don't be confused on that. So it in agency, it might be three party. There will be three party, but parties in terms of number of persons involved might be more than that, right? All right. Okay, the capacity of agent and principals. So basically, under the section 136, it says that in terms of capacity, who has the capability of being a principal and also being an agent. So under the law, under section 136, it says that any person who is the age of majority, according to the law to which he is subject and is of sound mind, may employ an agent. So this is principal. Basically, if you want to be a principal, so you must be at least 18 years old. So the age of majority is 18. At least 18 years old. This is to under the law. This is to be a principal. But as far as the agent is concerned, under section 137, any person may become agent But no person who is not of the age of majority and sound mind can become an agent, so as to be responsible to his principle according to the provision in the behalf herein contained. So basically, the law doesn't actually recommend a principle to appoint an agent which is not at the age of majority, or some mind, insane person, cannot be an agent. But how about if principal accidentally appoint a minor or a person underage to become an agent? Is it the contract is valid or not, between so that is the issue, okay. So we have, okay, any person can become an agent, including minors and some minor person. However, they are not responsible for their act. The principal must be responsible and take risk of their act. Right. So when a principal, so basically the law make it compulsory for a principal to be at the age of majority, right? But if the principal appoints an agent, for instance, a minor, right, right, on his behalf, right, and then subsequently the minor makes a contract on the name of the principal, the name of principal, then the principal must be responsible and take risk of their act. Oh. So that is the consequences. That is the consequence of appointing a minor or unsound mind. So I think a prudent principal, he or she actually will not appoint uh, a boy who is under the age, who is still studying at primary or secondary school to be his agent. So because as you know that people under the age, their maturity, the problems of the maturity, they are still maybe immature. They are not matured. They might do uh, something which is not up to the level of those adult persons. So in terms of their thoughts, their capability of making decisions, so it might affect the transactions, the business transactions. So it's very risky for a principal to appoint a minor or unsound mind. I think for a minor it can be forgiven, but for unsound mind I think is something weird, if a person can appoint such a insane person to be his agent, be his agent. So we have a case here, Chan Win-T versus William Jack. So this has happened in 1964, whereby in this case Chan and Yong, in this case Yong is underage, the minor, were partners in business, and Chan told William, third party, that Yong is his partner and has authority to act on his behalf. So William Jack supplied good to Yong, but no payment was made. No payment was made. So in this case, William Jack is a plaintiff, make brought an action against Chan, as principal of Yong. So in this case, the court held that Chan was responsible to Yong's act, no matter he is an adult or a minor. So in this case, basically, uh, even though Yong is Chan's partner, but in terms of the liability, the court will ask the adults, in this case chance, to be responsible to make a payment to William Jack, which is the plaintiff. So I think in this case, William Jack in this case is uh, respondent lah. In this case, Chan is a plaintiff. Sorry, Chan is a appellant. So this case describe give a lesson to us that if a principal appoints a minor as his agent, the law regards that the principal as an adult to be responsible to whatever the consequences arising from the transactions. Okay, there are two, in terms of the contractual relationship, there are two kinds of contractual relationship. One is between principal and agent, and secondly between principal and third party. Okay, so there is no such contractual relationship between agent and principal. Right. So only between principal and agent, and principal and third party. So because once you give consent as a principal to give authority to the agent to act on his behalf, so this is it actually arises a kind of contractual relationship between a principal and an agent, right? But to be an agent, actually there is no need under the law that both party must have a black and white. Meaning to say no specific formality in order to form a contract of agency. So it can be impliedly, or in other words can be expressly, explicitly written down in the black and white, or can be implied terms. So it's not actually compulsory for a person as a principal to write down an agreement in order for him to delegate his authority to his agent. So the law actually accept this kind of formality, but if you have a black and white, it's better lah. It's better to have a black and white. But in terms of creations of agency is concerned, the law doesn't make compulsory for principal and the agent to have an agreement, written agreement. And also no consideration is necessary to create an agency. This is under section 138. So we have learned about the consideration in the law of contract, whereby an offerer must be an consideration that being given by the offeree. In terms, if there is a contract, there must be a consideration. But in the agency, the consideration is not required. It's not required. Okay, modes of creations. So there are 5 methods of creations. One is the express appointment. Second is implied appointment, necessity, ratification, and estoppel, or holding out. Okay, so there are 5 modes of creation of agency. So if principals, right, appoint his an agent falls under one of these methods or modes, so there will be a agency takes place. Okay, first we discuss the express appointment. So express appointment doesn't mean it express doesn't it's not defined as what you call it fast. Yeah, it's not as bus express. It is more that the appointment is being made explicitly. Explicit appointment, in other words. Right. So for example, what is meant by explicit or express is when the principal appoints the agent and the appointment is made uh, in black and white. Sorry, in black and white. So that is meant by express appointment. So this is defined under section 139. And then it further defined or it further explained in section 140 that authority is said to be expressed when it's given by words spoken or written. Okay, so surprisingly, the law has actually explained that. So in order for appointment to be seen as an express appointment, right, it is not only in writing but also it can be made verbally. It can be made verbally. So this is very surprise, uh, uh, exciting, interesting method of appointment. So we thought that it's just in writing, but in terms of appointment, express appointment or explicit appointment, it can also be made in through a verbal, right? So verbally can be made as well, right? Okay, so I think this is understood. Second is through implied appointment. So under section 140, it said the authority is said to be implied when it is to be inferred from the circumstances of the case. So apart from express, which is through verbal and written or in writing, that the agent can also be appointed through the implied appointment. For instance, from the circumstances of the case. So this is very subjective. This is very subjective to some extent that only the court can determine whether there is implied appointment or not. But of course, when arguing in the case before the court, the both counsel can argue whether such circumstances render a person to be an agent. Right. So there are some actually cases to illustrate what kind of circumstances that can actually create a implied appointment. Okay, for example, in this illustration itself, under section 140, right, it says that, for example, A owns a shop in Kajang, living himself in Kuala Lumpur and visiting the shop occasionally. The said shop managed by B and he is in the habit of ordering goods from C. Okay, so in the name of A for the purpose of the shop and paying for them out of A's fund with A's acknowledged. So B has implied authority from A to order goods from C in the name of A for the purposes of the shop. So in this case, this is a clear-cut example of an agency, how the agency being created through the practices. In this case, the circumstances means the practices of the parties themselves. So when, for example, in the business transaction, whereby uh, an employee of the shop, for example, make an order, and then this is a practice being made, and this is very long practice being made by the owner of the shop, to delegate his power to his employee to order goods from the supplier, for example. So it's need not to be explicitly pointed by the employer. So it is impliedly being made. The appointment is impliedly being made, whereby through a practice for many years, for many months or many days. So it's example of implied authority. One is several of the case, and then relationship between husband and wife, right? So it is implied that the wife has authority to pledge her husband credit in the contract that are necessary, that in contract that are necessary and suited to the condition of standard of living. So in this case, the wife, the husband is the principal and the wife is the agent, because it is common. It is common for a husband. Not common actually. It is kind of under his duty to actually uh, satisfy the needs and necessaries of the wife's uh, living. For example, to buy his clothes, his to buy his food, something like that. So that is if the husband did not or doesn't actually perform his duty, but in fact the wife, for example, pledge a credit on his husband name, so the husband has to pay. Husband is regarded as a principal, and whatever the wife ordered or buys from the or make a credit, so the husband is liable to pay the price of the goods. But there is some defense for the husband. Okay, so especially when the husband especially forbid his wife from pledging his credit, if the husband can actually prove in the court that he especially forbid his wife from pledging his credit, in other words, he has forbidden the wife to make a loan. Number two, also he has warned the seller not to supply his wife with goods or credit, and his wife was sufficiently provided with the goods. His wife was given a sufficient allowance for buying goods without having to pledge her husband credit. Okay, and then the contract was unreasonable, taking into consideration her husband's income, right? So if the husband actually, but how about if the husband has give a warning to the seller, but the wife feel that the the she needs some that kind of things that are necessary for her life, for example, like food, something like that, clothes. So it might be debatable. It might be an issue where the husband has warned the seller, yet the wife argued that the husband doesn't give her needs or necessary for the living. So that would be something which is arguable. But to me, I think uh, even though actually the husband can argue that uh, he has won the seller not to supply or something, he has won the creditor not to give a loan. But if the wife actually is not given sufficient necessaries, so I think she has a good ground, a good ground for that, and then husband can be liable to to pay the price of the goods. Okay, so similarly, the Partnership Act, if you still remember, and then it says the agent, okay, a partner can also be an agent. A partner can be also an agent. So the firm would be liable. The partners, all the partners will be liable if the agent or one of the partners make a contract. Right. Number three, we call as necessity or emergency. So in this kind of modes or method of agency, so the agent is appointed during the emergency. Of course, there is no, in this case, there is no implied or express appointment. So the agent has been appointed in the event that that there is an emergency. There is an emergency events. So what is the emergency? So under the law, there is a requirement. There are some requirements where agency by necessity can be created. So what? Uh, so if the agents can prove that uh, the that he has to do the act because of the act is so imminent and so emergent, so that uh, they cannot be avoided. The situation cannot be avoided. So what are those conditions? Is that one, they must be a real or actual emergency. So how to prove that there is a real and actual emergency is a question of fact. It's a question of fact. Okay. So if there is a issue on that, so the court will determine whether such situation is emergency or not. So there, but later on we will discuss this. Number two, the agent's action is necessary to prevent loss to the principal or the agent was instructed. Okay. Number three, it is impossible for the agent to get principal's instruction at that time, and the agent acted in good faith. So, so there are four requirements. There are four requirements. There are four requirements in which that agency by necessity may be created. And these four requirements must be fulfilled. Must be fulfilled. So, okay, in the case of Phelps, James and Company versus Hill, in this case, the court defined that the emergency means that it must be a reasonable situations by looking into the dangerosity. Eh? So it means dangerosity, facilities available, cost, times, distance, etc. So these kinds of situation where the court uh, interprets what is meant by emergency. So among others, it can be when there is a danger, there is a danger, there is a problem in the facilities, there is an issue of facilities. Also, there is a issue on the cost, time, distance, and etc. So this is only the example that given by the court that can give a guideline to us. What kind of things, situations that can be defined as emergency. Okay, maybe if you say that, for example, cost, especially in the cost, business, they they always think about the cost, right? So if the agent feel that uh, he or she has, for example, uh, to buy certain goods or certain things at that time, because the cost might be maybe higher in the future. So it can be also one a good ground uh, for being an agent. Uh, so it's a good ground as emergency, because the cost and the times actually, because maybe there's no time, at the time, or maybe there is stock, eh? The goods is out of stock. It might be the only stock that they have in that particular storage, for example. So it can be a good ground for a real and actual emergency, and then that the agents could be created. So actually many other examples, but this is the kind of example that being given by the court. Okay, number two, the agent was instructed with the principal properties goods in the possession of the agents. An agent has authority in emergency to do all such act for the purpose of protecting his principal from loss. So this is about the authority given by the principal, that in the case of emergency, that the agent is given full power to protect the principals from loss. This is common sense. This, I think, the common sense in the case for, especially when the goods is perishable. So when the good is perishable, eh, for example, like it's getting expired. So maybe the agent or the employee at the time, maybe employee as an agent has no actually option, eh, except to, for example, to sell that particular goods, so to prevent the being perish. So that is a good ground also, of good ground of emergence, necessity, agency by necessity. So number three, is impossible for the agent to carry principles instruction. So maybe at the time of dealing with the third party, maybe at the time the agent has contacted already uh, the principal, his principal, but maybe it is not reachable, or maybe there is some other problems. So to some extent that the principle cannot be reached. So in this case, can also be a good ground. Actually, there is an effort made by the agent to contact his principal. To contact his principal, and then it's not reachable. The principal not reachable. So that is also another requirement, and necessity. And then okay, we have a case here: Springer and Great Western Railway Company. Okay, so in this case, we can see that um, the agent actually agreed to bring, so to carry the principal's tomatoes to some places, but uh, in between, before arriving the place, due to the bad weather, and also the time, um, they decided to not to sell the tomatoes, because he he thought that the tomatoes would perish before it arrive to the agreed place. So they didn't communicate with the principal. So I so in this case, of course, the agency by necessity is created, because 1921, at that time the communication is very limited. If you want to, if the agent want to call, it might be there is no such communications. It might be very takes very longer time. You need to have uh, you need to write a letter, and then the fastest way may be a telegram. So it is impossible actually to communicate, to give to get instruction from the principal. So in this case, it may be reasonable for the agent to sell his the principal's tomato. So what are the effects of agency by necessity? One, okay, so only one effect. So the agent will be protected. So the agent will be protected from any claim by the principal, and the agent will be entitled to additional payment for his effort to protect and to preserve the safety and trust of the principal. A contract exists between the principals and third party. One is the agent is not liable. Okay, number two, the agent will be entitled to the additional payment for his effort and protect to preserve the safety interest of principal if there is a extra charge lah. And the third one is there is a contract exists between the principal and third party. Okay, so there are basically three effects of agency by necessity. But number one is very important. Of course, the agent will be liable. Sorry, the agent will not be liable. So if there is a contract, so we need to say uh, the contract exists between the principal and the third party, right? So there is a case study I want you to read by yourself, and then try to get the answer, right? Number four, modes of creation of agency is by through a ratification. So what is ratifications? The word ratification and the root word is ratify. So ratify means that if uh, it is kind of not so certification, is kind of acceptance, a kind of acceptance or consent by the principal for an act done without authority or exceeding the authority given. So basically, ratification, agency by ratification takes place when the agent actually had done something, for instance, without authority or exceeding the authority. For example, without authority, for example, the agent actually is not given that power to do something, but later on, when it find out by the principal, the principal give a note, or give a consent, accepted his the agent's conduct, or in other situation whereby the agent has exceeded the authority given. For example, let's say the employee of the shop, the authority given is, for example, the employee can order goods from the supplier, for example, up to 10,000. But um, in in some circumstances, in some situations, a that employees or agents of the principal had exceeded his authority, whereby he ordered more than 10,000, so maybe 20,000, something like that, then that is exceeding the authority. So when it is found out by the principal, the principal may opt to choose whether to ratify or not. If he chooses to ratify, then there is the contract between principal and the third party or the supplier in this case takes place lah, because there is a ratification on that. Okay, so ratification may take place when the agent has done something without authority or exceeded the authority given. Okay. So in the event that the principal so the principal has two choices, one to reject or to accept the contract. So if he accept and confirm the contract, that means he ratifies the contract. Okay, many things, any liabilities, right, incurred, he has to bear that liabilities. Right. But if he rejects, he rejects, meaning to say the agent is liable. The agent would be liable. So it depends on the principal, right? Either to reject or to accept, to ratify. And ratification again may be expressed or may be implied. So maybe expressed meaning to say, if he find out the event or that kind of exceeding the authority or without authority, And another situation when it can be implied when he in some situation he keeps silent on that. Eh? For instance, uh, for example, he didn't give actually any sign whether to accept or not, to ratify or not, but he knows about that. He is aware about that. He is aware, but uh, he just keep silent about it. So that is implied. Implied means the conduct of the principle itself. Eh? Uh, when the principle is silent, that's one of the evidence lah. We can say that the principle is impliedly give a note for ratification. Uh, okay. Okay. Okay, all right. So if the principal doesn't agree, so the agency relationship exists. No agency relationship exists. So that is the effect. If the principal doesn't agree with the if the employee, sorry, if the agent makes exceeding his authority or without his authority to do something, then there is no contract between the principal and the third party, right? No contract, no liability. So I give an example here, right? I think this is very straightforward. Okay, when there is a ratification, the principal is bound to the contract. And bear in mind, another effect is that the principal is bound to that contract retrospectively. What is meant by retrospectively is that we need to say, because the contract be made by the agent, be made uh, before he ratified. Before he ratified, we need to say, let's say he ratifies today. So of course the contract between the agent and the third party had been made before, had been made last month, for example. So that means by retrospective. Means by retrospective. It can be uh, before the ratification as well as the future ratifications. So before we need to say last week, last month, yesterday, last year, or tomorrow, tomorrow, today, tomorrow, or next year, something like that. So that is meant by retrospective. But for the future, I think if the principal had actually give a warning, of course he give a warning to the agents. So we need to say he only ratifies for the previous we call it transaction, so that for the future it might be not be liable. Then so the principal has a ground, had a good ground not to be to ratify the future transactions. Right. Okay, so they only in the case of Bolton and Partners Limited and Lambert. This case very old. Old case 1889. It says that it was held that the contract is effective from the date when it was made, not from the date it was ratified by the principal. So in this case, the date is very crucial. Sometimes the date is very crucial because uh, the liabilities, and or the amounts of damages, the amount of damages being sued by the third party, eh? So that is the issue. So for instance, uh, if the contract, and there are several contracts, for instance, one it was made last month, for example, and then there is another contract, today's contract. So it will the effects of the ratification, retrospective effect, whereby last month's contract and today's contract are actually valid, once ratified. So we need to say not only today's contract lah. So that is meant by retrospective. So there are some condition, in order for a contract that can only be ratified. Of course, one, the contract done by the agent was without authority, or exceeding the authority. Number two, the act of contract must be recognized by law, not illegal. Okay, this is the second conditions. Okay, we have application, you have to read yourself. And the third one, the agent must, at the time of the contract, expressly act or agent will be simple. Okay, not on his capacity or personal capacity. So the agent must actually declare that his act was on behalf of the principals. Okay, can you yourself? So what is the evidence of that the agent act on his on behalf of his principal is that the agent use the name of the principal, not his own name. So that is the evidence. Okay, number 4, the principal must be in actual existence or capable of being ascertained when the contract is made. Okay, mean to say this is very basic of course. It must be certain, clear cut that the contract, for example, that the terms must be clear. The term, for example, in this case, Kellner and Baxter, a contract to buy a hotel by an agent on behalf of a company which was about to be formed couldn't be ratified by the company since it didn't exist at the time. Okay, so in other words, at the time of the contract, in this case, the hotel actually did not has not been actually been developed, so that it cannot be ratified, of course, because the subject matter of the contract itself doesn't exist. Okay, the principal must have contractual capacity at the time of the contract, and the principal must at the time of the ratification have full knowledge of all material facts, unless it can be proven that he intend to ratify the contract, whatever the fact may be. So the principal must know about the full fact of the of of the agents conduct, at the time of ratification, of course. So the principal, number 7, the principal must ratify the whole act or contract. So it cannot be in part. The principal must ratify the whole act done by this agent. Number 8, the ratification must be made within reasonable time. Okay. If it is expired or not reasonable time, might be will be problem with ratifications, right? So what is reasonable time is it depends on the fact. Okay, so it's a case by case. It's a case by case. Depends on the fact of the case. So, for example, like in this case, Metropolitan Asylum Board versus Kingham and Sons. So the agent contacted to buy eggs without the authority, so the principal tried to ratify the said contract. After a week it was made. So in this case ratification was too late. Because maybe because that the nature of the contract it is unreasonable. The time is actually not reasonable. Because buying eggs. So number 9, I think this is the last. The ratification must not injure third party's right or interest. So meaning to say there is no third party's right being affected by that ratification. So many actually. So many condition to be fulfilled. There are 9 conditions to be fulfilled in order for ratification to be valid. So very strict. 9 conditions. Otherwise, the contract is not binding on the principal. So it has to be fulfill all the requirement. So we have a case study here, right? So I hope you can read yourself and study try to get the answer. Number 5 is estoppel, creation of agency by estoppel. Estoppel, if you can still remember in the law of contract, right? So estoppel is a kind of principle under the rule of the equity, rules of equity, right? So this is actually totally principle developed by the decision of the English judges. So what happened in this case is in estoppel, where estoppel generally means a person is not bound by contract made on his behalf without his authority. Okay, so when the estoppel takes place in the agency is that when a principal who by conduct or words allows a third party to believe that the agent is acting on his behalf. So he is estopped. So this is what when the estoppel is come about. He is estopped or restrained from denying that the agent is working on his not on his behalf So in this case the principal actually made a signal so that signal can be either by words or by conduct. So by words is very easy. Very easy to detect. Very easy to trace. Very words. So we need to when the principal contacted or give actually assurance to the principal to the third party, that is by words. So that is very clear cut but very straightforward. But by conduct it might be implied. Very implied, and then it's to be interpreted whether such conduct can be construed as a estoppel. Right. So if in the event that the principal has given his signal, person to be his an agent and to be acted on his behalf, then estoppel or agency by estoppel can be maybe created. Okay, we have an example here. A tells T in the presence of P that okay, A is P's agent, and P doesn't contradict this statement. So P later cannot deny that A is his agent if T sells goods to A, believing him to be P's agent, and later claim for the price from P. So okay, so in this case A is principal, T is the third party, and the P is an agent. So the problem in this case is that when A tells T that P is an agent and P doesn't actually deny it, sorry. In this case, that in this case A is the agent. A is the agent, and he tells to T that P is the principal. P is the principal. So later on, P cannot actually deny that A is not his agent lah. So meaning to say, if T sells goods to A, so believing he is P agents, and then P has to pay lah. P has to pay because the fact that P does not actually deny the fact that maybe A is not his agent. So that is by estoppel. So this is the same like the principle in holding out the partnership. Okay, the effect of estoppel. So I think the effect is the same like a necessity whereby the principal is bound by those act, obligation. Okay. And there is a estoppel. Okay, the principal has the liability and bound to contract that be made by the agent. When a principal doesn't inform or announce to the third party that his agent has no authority. Okay, of course not. So in this case, if the principal want to terminate the agent, the principal has to inform the agent, the third party, the third party that the agent has been terminated. Otherwise, it will last. It will last until such notice being given. So that is the effect. So we have a case here. You can read yourself. Okay, the summary is this in the agency by estoppel only happen if the principal himself through his own words or conduct induce the third party to believe that a certain person has the authority to act on his behalf. But it doesn't happen if the third party was induced by the agent only. So in this case, it is necessary for the principals, the principal, to make a belief that to make believe that the agents have been appointed by the by principals to the third party. If the agent himself convinced that he's an agent of principal to the third party, then it will not be happen. The agency by estoppel cannot be happen. So only when principal itself give that by his own words or conduct give a signal to the third party that the person is his agent. So that is